What's up, viewers, subscribers, and agents alike? It's your boy Enlightened Sphere Prince coming at y'all once again. In my previous video, or I should say previous videos, much more or less, I described something in regards to federal routing numbers. Now, this is not what this topic is going to be about, so don't get it misconstrued. But I'm going to say that, again, that's a topic for people who have the legal competency to actually exercise that. And what I will say is again, as confusing and as confounding as it may sound to most people, it's only used particularly for informational and educational purposes only. Now, secondly, a lot of people say that it doesn't work or yada, 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 or whatever case may be. I'm not going to elaborate on that point because, to be honest with you, that's something that you have to deal with in your personal assessment. And anything that you deal with, as I said years before, when it comes to these processes, you have to deal with it in your corrective and respective responsibility. What does this mean? If I'm informing you of something and I'm giving you the information that's particularly pertinent to your cause, it is not my responsibility to elaborate upon what it is I'm actually giving to you. Most people say, well, what do you mean? Well, put it like this. If your vehicle breaks down and you turn around and ask me to borrow my car, fine, you should borrow my car. But that doesn't mean I have to drive it for you because I don't know what destination you're headed. So the vehicle was the information and the destination is your application. So take that into strict consideration. But be that neither here nor there. That's something for another time. By the way, everybody that inquired about certain situations prior to that, I answer your emails. It is what it is. Period. I answer your emails. Stay on top of my game. Okay. Topic of discussion today is going to be the Fair Debt Collection Practices Act. Quote, let's see. Title 15, United States Code, Section 1692. And it's also going to be the currentness on it, which is the 15 United States Code annotated Section 1692. So, let me elaborate on something before I proceed. Before I get into all this does not constitute legal advice, nor does it establish anything anti-government. The sole purpose of this video is for informational and educational purposes only. Now, what is the Fair Debt Collection Practices Act? It was an act that was actually established by quote-unquote congressional findings and the Declaration of Purposes under Title 15 United States Code 1692, where it says in the subsection A, abusive practices. There is an abundant evidence of the use of abusive, deceptive, and unfair debt collection practices by many debt collectors. Abusive debt collection practices contribute to the number of personal bankruptcies, to marital instability, to the loss of jobs, and to the evasions of individual privacy. Here we go. B, the inadequacies of law, meaning that there's no particular provisions that existed heretofore which were promulgated before this actually was established. Remember that. Existing laws and procedures for redressing these injuries are adequate to protect consumers. Subsection C, available non-abusive collection method, meaning no other than misrepresentation, which is fraud, or other abusive debt collection practices are available for the effective collection of debt. Subsection D, abusive debt collection practices are carried on to a substantial extent in interstate commerce and through means of instrumentalities of such commerce. Even where abusive debt collection practices are purely intrastate in character, they are nevertheless directly affect interstate commerce. Subsection E, purposes. It is the purpose of this subchapter to eliminate abusive debt collection practices by debt collectors, to ensure that those debt collectors who refrain from using abusive debt collection practices are not competitively disadvantaged, and to promote consistent state action to protect consumers against debt collection abuses. Now, here's where you can find this law. I didn't make this up. This is on paper for all you naysayers. Credits, public law 90-321, Title VII, Section 802, as added, Public Law 95-109, September 20th, 1977, Statute 874. Current through Public Law 114 through 248. Now, let's go into the actual, I want to misplace that, basis on what the definitive purpose is when it comes to this act. See, this act blatantly explained to you in plain English exactly what the act is consistent of, but it doesn't explain to you in the legalese ideology of what it means. So, stick with me what I'm getting ready to say. Okay, Fair Debt Collection Practices Act. The FDCPA provides 1. Collection by the emphasis added actual creditor is not affected by rules set forth within the act. Now, we're going to take that word actual creditor and we're going to embolden it. And we're going to say this. I'm going to say the actual person who the credit is owed to, not whom the debt is actually laid to, but whom purports to actually want to accept this debt. Now, most people are like, well, what do you mean? That sounds like a mouthful. Okay, let's put it in layman's terms. Are you a secured party creditor? So if you're a secured party creditor, you have the documentation to prove it. Guess what? This is what they mean by actual creditor. Let's go further. Contact the Federal Trade Commission for the enforcement of any rules provided for this act. 3. Collection agencies are not allowed to contact a debtor at unreasonable hours, places, or any friend, family members, nor at jobs. In other words, they cannot harass you. So all you people that's out there in YouTube land, stop being fearful and tell these people to fuck off. Because according to certain subsections, and pardon my language if you're sitting around children, but the truth is, when it comes down to it, according to the Fair Debt Collection Practices Act, you only have to actually be notified them one time. So all you people that's out there in the YouTube world that keep getting these collection notices, y'all need to start sending those back. And what you need to do is actually, in another video for another time, because I can't load it all in this one, because it'd be too much. My head might pop. But they're only supposed to notify you once. They can't sit here and call. If you have a brother or sister, mother, grandmother, uncle, whatever, they cannot contact them in regards to your debt. Because first off, it's none of their business. These are instances where they shouldn't even be sitting here putting your business, that's private, on the public side. So that's when you can enforce that particular policy, and you can actually sue these people in federal court. Now, in certain instances, I will say disclaimer. If your employer consents to it, to keep being harassed, it is what it is. They can come to your place of work and they can harass you at your place of work if your employer consents to it. But if you know your personal debts and you know what you have going on in your personal life, you shouldn't give anyone the permissibility to actually have these people assess you in a public environment. Remember that. Keep your private business private, period. Let's go further. Number 4, collection agencies cannot directly contact a debtor who has made it clear that he or she is being represented by an attorney. Period. They have to talk to your attorney for those of people who in YouTube land use attorneys. I don't. I'm power of attorney in fact. Number 5, collection agencies are not permitted to use threatening language, intimidation tactics, false or misleading statements, abusive language such as curse words. Make sure you keep your phone calls recorded when these people call you too. Or hide their true identity and or purpose/intent. Number 6, collection agencies must show in writing the notice and amount owed and to whom it is owed within 5 days of their first attempt of communication with the debtor. That's the first initial contact, period. Number 7, collection agencies must initiate any suits in the jurisdiction and locate the debtor and or wherever the contract was actually first created. That's right. The place where it was created. That means if an entity that's in California tries to contact you about a debt and your actual contract was initiated in, let's just say, Colorado, that motherfucker has to catch a flight and prove the actual validity of the debt, which incurs the penalty anyway, because that means that somebody has already paid the debt because they sold it all to a collection agency. That's a proven fact. It's fraud in and of itself. Now, what rightful person who wishes to obtain something through fraudulent means is going to actually hold themselves accountable? Answer that question yourself. You don't have to leave it in the comment section. Number 8, the debtor has the absolute right to challenge the validity of the debt. The debtor, not the creditor. At which point, all attempts at collection of debt must cease until the debt collector proves the debt in the manner stipulated by the debtor. Number 9, if the collection agencies should violate the rules set forth in this act, the collector becomes liable for damages such as criminal complaints, civil suits, commercial liens, UCC 1, use of a cease and desist order, which I'll do in my next video, court costs, and attorney's fees. And you just learned a very significant truth in less than 11 minutes. Let's go forth. I'm going to go forth a little bit more. Let's go. Here we go. Contracts, offers, and proper service. Every piece of mail, citation, application, plea deal, etc. is an offer presented which can always be accepted, rejected, modified, where the power lies in knowing how to reject an offer properly while still remaining in honor, which means that you're going about it the right way. You're not just sitting here letting this piece of paper that says that you have to appear in court to sit on your desk, your table, or whatever. You're actually sitting here addressing these issues. But the sad thing is that people don't know the actual honor as opposed to dishonor. But remember, remaining in honor is the protective barrier which establishes the clear difference between obligation and liability of freedom and exemption. Not going to go no further because, like I said, I don't want society's head to bust. I know we live in a debt-laden society. It is what it is. We know this. And a lot of people are sitting here stressing and straining over things that they really have to come to a cognizance of anyway. Straight. But on my channel, I try to take people step by step. Step by step. Because in order for you to be successful in this, you have to know how to navigate. And you have to know the tricks that these people will wish to employ. They'll turn around and explain to you that you particularly owe something. But the sad thing is, majority of the population, how stupid they are, they'll just bow down and acquiesce. Or they'll sit here and argue without having any validity in which they say they owe. Well, you owe $5,000 some odd dollars, whatever. The average person will try to go to banks, try to get loans, try to call family members, try to sit here and go all the way around the board instead of challenging what they said you owe in the first place. It's not hard. The acceptance for value program, I should say, it's not a school, it's not a university, it's not an institution. It's your inability to pay something that pays for it. Remember that. Now, am I saying that you should go out there and incur debt just for the sake of actually making sure you don't owe a debt? No. Universe forbid I would ever direct people in that direction. Universe forbid it. But what I will say is this. Those of the majority of people who view this channel who do have them, I suggest you start doing ASAP. If this is your first time viewing this video, like and subscribe. Share the video, please. Smash the like button. Save the videos. Share them on social media. Don't care. It is what it is. From this point forward, there's a lot more information to share, but in such little time, we can't digest on it all because people will get the concepts confused and then I'll have to explain it again. And I will say this on my current video, people who contact me, if indeed you wish to schedule a consultation, and this means that you are taking a shrivel out of my day for me to obligate myself to contact you, please do know, and I can say this openly, that time is not free. See, this is free time. I can do this all day. And I know that some people may have a variance about that, but I'll tell you what, if you do, go find your fucking lawyer and look it up on the yellow pages online if you can't find one, or you can go to LegalZoom. Go ask them what they charge for consultations. Go ask them. I guarantee you can't afford it. They don't give you this information because they know if they did, they'd profit off of it. They would not profit off of it based upon the concept of them actually disseminating to you publicly during the consultation. So they know that they have to keep you in a state of ignorance because they know that, hell, if I tell you the truth, I won't have a job. But I would challenge anyone on these YouTube networks, any one of these YouTube channels, please call any lawyer you want. Any last one of them. Don't care whatever state you choose, from what they say, sea to shining sea. Anyone. They're going to tax you out the ass. Literally. Straight. The average high-powered lawyer, average, circumspect, did my research, charges anywhere between $3,700 to $4,000 just for a retainer. Just for retaining. Then, if you wish for them to enter pleadings on your behalf in open court, they charge you $450 to $600 per motion. Now, for them to actually appear in court on your behalf, that's tens of thousands of dollars, and it's on a fee scale, sliding scale basis. Come on now, you're paying for their trip, their expenses, their food, everything, straight. But because I don't have a suit on, and I don't have books behind me, and I don't have a nice fancy desk, it's hard to understand. Well, let a fool be a fool. Let a wise man be a wise man, period. But again, if you actually want me to explain these things, just let you know, I set consultations at certain times with certain people. If you're serious. And I will tell you, yes, they cost. I'm going to make that blatantly clear. You know what I'm saying? For whoever has anything to say about it. Yeah, it does. I got a family. I got a life too. I got things I got to do. You know, and I dedicate most of my time to YouTube just on the general strength of the benevolence to actually educating a lot of people on these channels, irrespective of race. Don't care. I leave my PayPal description in this shit. Leave my email address. The same as they would do if they actually gave you a business card. But no, lo and behold, y'all like smelling cheap coffee and looking at secretaries and explaining their problems to you, and they're going to sit there and pretend like they don't know what you're talking about because you ain't giving them no dime or no time. Come on. Here's what it is. If I had a law firm, I swear to God. That was shit y'all wouldn't even understand or even know about, because at the same token, it's still the legal system. Period. This is how they move. This is how they maneuver. Y'all better take that in strict consideration. Straight. Those who are serious, contact me. It is what it is. Other than that, peace. It is what it is. Other than that, fuck the agents. Take care. Stay tuned.